Intervention. Intervention is a rule that says that a non-party who thinks they have a right to participate in the action, who thinks that complete relief cannot be afforded without them being involved, can intervene in action, can ask, request to be made a party to the action, even though the plaintiff or the defendant, any of the parties, aren't requesting that person to be a part of the action. Let me give you an example. Let's say we have an insurance policy, and the insurance policy has named two people as the insured. It is named a condominium, and it is named an individual person called Joe Smith. And there was damage to the condominium, as well as Joe Smith's unit, and the condominium has sued the insurance company for non-payment because they refused to pay for the damage that was caused, let's say, by a storm. The condominium thinks it's got everybody they need to sue. The insurance company is perfectly fine to have one person suing them. However, Joe Smith thinks that he wants to be a part of that because he believes he's entitled to some relief, or he believes that complete relief cannot be given without him being a party to that. And so he wants to find a way to get into that action. The way he does that is by filing a request, a motion to intervene, and to explain why it is necessary or required for him to be a part of that litigation. And in many circumstances, when they intervene, they'll actually have their own complaint or their own set of defenses, depending on whether they're a plaintiff or a defendant who's intervening, that will be attached to a request so that the court can see not only the reason for them getting involved, but what they would be asserting if they became a party. That's the classic way to understand the rule of intervention. There are two kinds of intervention. That is intervention that's granted as a matter of right, or intervention that is permissive. And the different rules that are contained within the intervention process are really self-explanatory. In other words, if there is a federal statute, for example, that gives you an absolute right to intervene in an action, then you can understand that I can intervene as a matter of right. A court really doesn't have much jurisdiction or much discretion to deny your right to intervene. There's also things like permissive intervention, where a federal statute, for example, might say that you could be a party to an action, but it doesn't say you have to be, and it doesn't say you have a right to be. In that situation, you would have a permissive type of intervention. If you can demonstrate that your claims are so necessarily intertwined that it is impossible to grant relief without you being a party, that's more like a mandatory intervention, or intervention as a matter of right. If your claims might have some relation, and you might be a good person to be a part of that litigation, because it would probably or likely result in some benefit to all the parties or benefit to you, but you also might be able to get relief by some other method, that would be a permissive manner where the court has discretion to grant or deny. Understanding those distinctions can help you with understanding what your rights are and when you may be able to intervene.